Okay, the H1B Guy Live here. And today, the H1B Guy Live, unedited, unscripted Q&A 6, talking about the H1B lottery updates, the November Visa Bulletin that was released today, and celebrating our 75th post here on YouTube. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube. It helps me to produce more content like this for you. I also wanted to mention that the H1B Guy offers a variety of consulting services. If I can help provide you peace of mind and bridge the gap between your immigration attorney and your employer, please reach out. I'd love to hear how I can help you. I also wanted to just say thank you to all of those who have taken the time to join me here today. We definitely have a lot to talk about. Um, Late last night, a huge announcement came down from DHS where they submitted a notice that will be published on the Federal Register. And so I wanted to cover that, the DHS lottery changes that were announced late last night. I'm going to read a little bit of the news release, and then I'm going to also read a little bit of the data that the notice that the DHS is going to provide, and it'll be published on the Federal Register. So a little bit of this is scripted today, but I just think it's very important to cover the context so that we can talk about it. For those of you who are joining today, if you have any questions or comments, I'm going to ask you to please post them in the chat here on YouTube. I'm also going to ask you if you can like this video. Really helps with the YouTube algorithm and getting the live streams promoted now as well as later on. So with that being said, I wanted to move on to the press release that was titled DHS Trump Administration Protect American Jobs from Unfair International Competition. DHS Trump Administration protects American jobs from unfair international competition. The agency proposes prioritizing higher wage levels to better protect U.S. workers. Today, the Department of Homeland Security has announced the transmission to the Federal Register of a notice of proposed rulemaking, the NPRM, that would prioritize the selection of H-1B registrations or petitions if the registration process is suspended, based on corresponding wage levels in order to better protect the economic interests of U.S. workers while still allowing U.S. employers to meet their personal needs and remain globally competitive. Modifying the H-1B cap selection process by replacing the random selection process with a wage level based selection process is a better way to allocate H-1Bs when demand exceeds supply. If finalized as proposed, the new selection process would incentivize employers to offer higher wages or petition for positions requiring higher skills and higher skilled workers instead of using the program to fill relatively lower paid vacancies. This effort would only affect H-1B registrations submitted by prospective petitioners seeking the H-1B cap subject petitions. And then DHS will open public comment once the NPRM is published in the Federal Register. Interested parties will have 30 days to submit comments relevant to the proposed rule and 60 days to submit comments relative to the proposed information collection. So very interesting here. We see, the NPRM from DHS, and I wanted to just kind of read a little bit of the proposed. So it says a wage level based selection is also consistent with the administration's goal of improving policies such that the H-1B classification is more likely to be awarded to petitioners seeking to employ higher skilled and higher paid beneficiaries. Simply put, because of the demand for H-1Bs has exceeded the annual supply, DHS prefers the cap subject H-1B visas go to beneficiaries earning the highest wages relative to their SOC codes in areas of intended employment. Specifically, DHS proposes that if more registrations were received during the annual initial registration period than necessary to reach applicable numerical allocation, USCIS would rank and select the registrations received generally on the basis of the highest OES wage level that the preferred wage were to equal or exceed the relevant SOC code in the area of intended employment, beginning with the OES wage level 4 and proceeding in descending order with OES wage levels 3, 2, and 1. Very interesting. And of course, OES is the occupational employment statistics wage level that we use. If the preferred wage were to fall below an OES wage level 1 because the preferred wage were based on a prevailing wage from another legitimate source or an independent authoritative source, USCIS would rank the registration in the same category as the OES wage level. If more registrations were submitted on the final registration date than necessary to reach the regular cap, USCIS would rank and select registrations from among those submitted on the final registration date, generally based on the highest corresponding OES wage level that the preferred wage equals or exceeds for the relevant SOC code in the area of intended employment. Thereafter, USCIS would complete the same ranking and selection to meet the advanced degree exemptions. Wow, so this is just huge reform that was dropped late yesterday to the H-1B lottery as we know it. What's really interesting with this shift, last year, at the beginning of the year, it was announced, or towards the end of last year, it was announced that the HCAP lottery was going electronic. And so I would think, kind of based on that, this should be pretty easy for USCIS to sort, these registrations or petitions based on wage levels. Of course, the interesting point here is that the wage level is based on the area of occupation. So we're still talking about median wages based on the location. I was having a discussion earlier today on Twitter about this, and the interesting point that came up is that wage is not a skill, and I honestly hadn't thought about it like that. But I do think wage is a merit, and of course, here on this channel, we've talked about it a lot. Um, Merit-based immigration system and what that would look like here in the U.S. But as I thought about it, I mean, I think wage is a merit, but it does take skill to earn it. So there is a fine line there. Um, the other thought that I had around this was it definitely gives a lot more power to big tech and employers with very deep pockets. And the reason why I say that is that when we're talking about bidding, which is what this is really becoming, it's talking about preference will be given to employers who are paying above the prevailing wage. It's a very interesting concept, not something that we've seen before. That's a merit-based preference, right? So it's very interesting to see this language be put in this notice. So I don't think that this is necessarily a bad thing. I think the random selection of the lottery and the way that it created this flooding and multiple petitions for the same beneficiary, it really wasn't the way the system was intended to work. But unfortunately, there wasn't a lot of modification and reform to it. If we go back, the preference started, I think it was 2019, where we had a rule that was posted on the Federal Register that changed the way that the selection process would be adapted for advanced degrees and then international bachelors. So I think this rule is an interesting one. I know that based on what I was reading late last night and this morning, there's a lot of support in favor of this rule. And so, I can't say that for me that I'm against it or I disagree with it, but I'm interested to see how it's going to play out. I think what you'll see is it's going to hurt a lot of the smaller tech startups that maybe have identified an offshore based resource that they want to bring here, that they potentially aren't paying, you know, above the prevailing wage per se, and the case may not be selected. Uh, but I think this is a very interesting notice to be posted. Thursday, we are 5 days away from the election. You're looking at, a 30, 60-day period for this, which would put, based on some fuzzy math here, would put it right at the end of the year, the calendar year. So, I think, again, you're seeing and have seen very rapidly over the last 6 months some very aggressive, accelerated reform, as even alluded to in the text, by the current administration. So again, I think it's some of this is good. How it's going to impact and play out the selection process, to me, it kind of becomes more of a survival of the fittest. It's eliminating a lot of the cheap labor debate that we see out there, the undercutting of U.S. and American workers' wages. It completely removes that. It says it specifically. We don't want to see the level 1 and 2s. We want to see 4s and 3s. So hopefully this will be a good thing. We'll keep an eye on that over the next couple of months to see how this rule transpires. So I wanted to move on to the November Visa Bulletin that came out this morning. If you are currently watching this live stream, I'd like to ask you to please like this video. If you're catching it on a replay, if you don't mind hitting that like button, I really would appreciate it. We talked about the November Visa Bulletin last Thursday, and I gave my predictions. I thought that it was going to be posted last Thursday, and then when it didn't come out, it definitely felt like it would be today. I was right in that assumption, but I was wrong, completely wrong, when we talk about what the Department of State means when they imply rapid forward movement. The notice today was very quiet, very little chatter on it. I did want to cover some of the forward movement and talk about what I think that means going forward. I noticed at the very end of the November Visa Bulletin, there was no mention of rapid forward movement. So, interesting to see that language be completely removed. But let's talk about final action dates first. So final action dates for EB2 in China, it moved forward 6 weeks. Okay. And the current final action date for China is April 22nd, 2016. The EB3 date for China, final action date, moved forward 3 months. Okay, so that now is a final action date of October 1st of 2017. So the movement final action date as it relates to EB2 India, it moved forward 21 days. And that date was September 22nd, 2009. As for EB3 India, it moved forward 6 weeks, and that date now is March 1st of 2010. So as it relates to final action dates and the Department of State's interpretation of what rapid forward movement is, we see the maximum forward movement was 3 months for EB3 China. I wouldn't necessarily refer to that as rapid forward movement, but I guess if we look at September, August, where there was no movement, you could maybe refer to it as rapid forward movement based on the previous months. But the bigger one, and the one that created a lot of chatter and a lot of sort of anxiety and a lot of individuals trying to figure out, hey, what's next? What do I need to do? Were the filing dates that came from the October Visa Bulletin. And so the filing dates for November, based on what I see, is that there is no movement. So what does this all mean as we try to unpack it? As I did on the video last Tuesday when I covered the I-140 filings and approvals, we did some basic math and we talked about roughly 60,000+ individuals that would fall under the filing date that was posted as EB3, and roughly about 30,000 or so that were in EB2 that potentially were looking to downgrade. I expected a little bit more movement. Of course, I said 18 months. Looking back on it, that was an aggressive number. I think if you said 90 days, then you hit the home run if you're talking about predictions. So now the question becomes, what does December look like? And when will that December notice be posted? Um, you have to think, Thanksgiving, the last week of November, I believe is the 26th, and you're talking about Friday the 27th. So, you're getting into really the beginning of a week, and historically, as we've seen, the Department of State likes to post these out on Thursdays. So, I don't know. What do you guys who are currently watching? Curious what you all think about what December could look like, about the movement here in November, and what little it was, and how the Department of State implies and refers to rapid forward movement. I think now we know what they mean by that. It means 6 weeks to 90 days. With that being said, wanted to move on here to the Twitter Q&A for the day. Going to pull up just a comment that I received from my good friend at dark_night 1587. This is in reference to the DHS's discussion and notice to reform, where it says, personally, I think it's a step in the right direction. We kind of went back and forth on this. We talked about it a little bit. Yeah, I mean, I think hopefully it is, but what is that long-term impact? And I guess the concern for me, and we've been talking about this a good bit, is that the power right now is in the employers. And when we look at a rule like this, I think it just gives the bigger employers with the deeper pockets more power, and could potentially suppress some of those middle market tech startups and small businesses. And is that necessarily a good thing? I'm not sure. I think that's a to be determined. We'll see how that plays out. So this is at EV Guy 7. First question: how would it work with upcoming DOL wage increase? Does that mean future H-1B holders will be 10 to 15-year plus senior applicants? So I don't think that that's what this is going to mean. I think when you look at what the minimum requirements are, right, for an H-1B, bachelor's in 5 years of experience or a master's in 3 years of experience, documented, right? Um, I think it comes down to ultimately who's willing to pay that individual, the beneficiary, above the prevailing wage, right? That's what it's going to come down to. So really, it isn't a matter of, I think, years of experience. Ultimately, the more years of experience you have, the more compensation you can command. It goes back to the merit component, right? But I'm not sure exactly if it will have that impact. I think it's going to be, what's the niche skill and what's that wage associated? What's the employer willing to pay? I definitely think what it will do is it will cut out on the 3 years master's degree working for, the large integrators that are receiving 65K wage one level compensation. I think it will impact that immediately, right? But that may go without saying. So second question, those who are stuck in backlog, would they be subject to this rule in their next renewal? So I would say no. The reason being is that it's specifically referring to the H-1B lottery as it relates to the cap. And what it's trying to do is curb the excess amount of petitions that are received annually. And I think in doing so, what it does is it takes away employers filing multiple petitions, as well as individuals who may have multiple petitions being submitted and filed on their behalf. So I think those that are stuck in backlog, they're not going to be subject to this particular rule. But if we go back to the wage level increase, which the the H-1B IFR, which we've talked about, you're definitely going to be subject to that unless there is an injunction based on the lawsuits that have been filed in court. But the way I'm interpreting, if I were to take your question and apply it to the H-1B IFR, I would say 100% yes. If you're preparing to file your extension right now until the court has ruled on the lawsuits that have been filed, then I would make sure that you're meeting the current new wage levels. And then the last question here, should they make the process transparent so Americans can see what is wage of lowest and highest applicant, their field of study, education level, etc., so people can understand what employers are really interested in? Yeah, I mean, I think, the interesting part here is you can look at the SOC code, the job code, and know you have an idea of the numbers that have been filed. But I don't specifically know if I guess those wages are public information, right? Because you're talking about the Department of Labor is certifying the labor condition application for those roles before they can be filed. So I think, yeah, one of the things we've been talking about is more transparency. And that goes back to, the electronic filing system and how data collection, cloud storage, we're talking about cutting edge digital transformation type technology could really impact what our immigration system looks like. It could cut down on fraud, it could eliminate abuse. Why? Because we have documents that are collected and stored, and individuals are now profiled. I mean, that's really what it comes down to is that we're profiling. Any good staffing firm that is worth any weight, um, they've profiled your candidacy, right? There is a profile created in an applicant tracking system that has you profiled, multiple copies of your resume, notes documented on communication, uh, emails, correspondence, things like that. So I think USCIS could very easily implement some sort of similar system when it comes down to electronic filing and how they would track each of those individuals. Um, it would make it a lot easier to run extensive reporting, uh, more transparency for the American people as to who is holding these visas and where are they working. Again, it comes down to public notice, which is what an LCA actually is without an individual's name written on it. It is public notice. Um, so thank you, at EV Guy 7 for those questions. I believe I had a couple of others coming on Twitter here. Um, so I think what it looks like here, couple little bit more chatter talking about the rule, and a lot of folks are talking about where does this move the power. And as we've talked about a good bit, it sure has felt like lately a lot of the powers has been in the hands of the employers. So okay, wanted to get to some of the YouTube questions that have come in, and then once we get through these, I want to do a little bit of celebrating with you guys here. So thank you to everyone who's taken the time to join the stream. If you haven't already, please like this video. Just really appreciate your support in doing that. And let's see here. So Depender asks, I got my EAD in February of 2012. I've used my EAD to change employer in October of 2012. However, I did not file an AC-21 letter. There was no form 485J at the time, and I changed employer. Now my date is about to be current. Will this cause issues? Should I go ahead and file the I-485J? So I'm assuming that you've changed employers is what it sounds like. And I'm guessing you've had your EAD since February 2012. Probably sounds like you've been working under that EAD as an advanced parolee. If you've been with the same employer since October of 2012, I would assume that you're going to need to file that. because you're talking about adjusting status that was based on if it was a previously approved I-140. Um, that's an interesting question. I haven't seen that before. Just if you're looking at your dates, I mean, you're talking about 8 years in EAD. It's a long time. Oh, you changed employers in 2016. I'm sorry, I see it now. Um, if you've been with that same employer for the last 4 years, I'm assuming you've been working for them under your EAD, continually renewing that in 2-year increments. I still believe you're going to need to file that the I-485J. Again, full disclosure, I'm not an immigration attorney or a paralegal. This is merely my opinion and advice. There's no guarantees, of course, in my advice's outcome. But I think to be safe, when you get to that adjustment of status, right, because that's what we're talking about, um, you want to make sure that you're eliminating any questions about who's your current employer and about the need for your employment, right? So I think that's where that comes into play. But Depender, thank you for your question. If I didn't answer it and you're still watching, post another comment here in the stream, and I'll get to it at the end. So let's see. At Master Tentamon asks, how will the advanced degree cap be handled with the new system? So the way I interpreted it is it's the same process. Okay. So the same selection process will be given to advanced degree caps, meaning prevailing wage determination, employers that are paying above that will be given preference. Okay. So I don't think that there's any change in that interpretation in terms of the way that I read it. So my understanding is that it really feels like even in the advanced degree categories, you're talking about the pool of 20,000, right? So individuals who came here to the US and earned an advanced degree, it's still going to be those that are being paid the highest wage will get preference, will be selected. That's the way I'm interpreting it. I'm assuming that you probably are interpreting it the same way based on the language. Let me know. But yeah, I think that from everything that I've read, and I'll just go back to what I mentioned here is that this is from the notice that will be on the Federal Register. It says thereafter USCIS would complete the same ranking and selection process to meet the advanced degree exemption. So yeah, the exact same process it sounds like. And what I'm interpreting based on this is that they're trying to cut down on the excess filings outside of making sure that H-1Bs are being paid well above prevailing wage determinations. They're trying to cut down on the excess filings. Now, the interesting part about them trying to cut down on excess filings is that USCIS is a fee-based model, right? But if your case is not selected, what happens? Fees are returned, but guess whose fees are not returned? Any immigration attorney who took time to prepare that case, those legal fees are not returned. But if your case is not selected, the fees that the employer, the petitioner paid on your behalf, they are returned. So, uh, Master Tudemon, thank you for your question. Really appreciate you taking the time to join here. And I think I've got another question from you I'll get to in a second. Matt Synapse 660. Hey, thank you for joining me here on this stream again today. Really appreciate your support and taking the time to ask me another question. Do you expect any movements and dates of EB filing for EB3 India until October 2021? I mean, that's an interesting question and not something that I thought about, right? I think for me, when I really think about it, I thought when you go back to the language and it kind of a point that I made earlier, which is when I think about what does rapid forward movement mean? To me, it means more than 6 weeks or 3 months, but it doesn't mean that to the Department of State, right? So The fact that the filing date didn't move is interesting. And now that you ask this question, it's interesting. I think I would be better suited to give you a better prediction in January. Um, and I know that's kind of punting on the question, but to answer your question, I sure hope so. I mean, I'd like to see some sort of movement, but we're talking about filing dates, which really was the eyebrow raiser, right? I mean, you're looking at some pretty excessive dating. I mean, January 1st of 2015. And so I don't know. I think that the fact that that filing date moved as much as it did in October and the buzz and panic that it created, and now not to move in November, it says a lot. So let's keep watching this. You and I can definitely come back to this question at a later date. I don't know. What do you think? I've got some time. What is your prediction? You tell me. Is it going to move? Do you think that we'll see any more movement, or will we be stuck where we are? Okay, at Master Tudemon asks, are stocks, bonuses, etc., taken into account for wage level consideration? I think that answer is no, because those are incentives as part of the total package. And when you report prevailing wages, you're talking about the guaranteed wage that the employee will receive, right? So I'm just going to use Washington, D.C. as an example. I'm a Java engineer working in Washington, D.C. Okay, so my prevailing wage determination for a level 3 is 116K. Based on the new wage level, I'm now 142K. All right, I'm just kind of making some numbers up here. Um, if my case were a lottery case and the new wage level for my level 3 is 142K, if I'm being submitted into the lottery, I'm going to need to be submitted by the employer with a guarantee or documentation showing that I'm being paid at or above the 142K. And so stocks and bonuses don't do that because they're not guaranteed. Okay. So that answer I think is no. Let's see. At Tess S, LCA wage is different for union positions, right? I don't know that answer. I've not come across any H1Bs working in unions in my experience. If there are, I'd love to hear about one. I'd be very interested to research that and talk about that. Um, but my understanding is that the LCA is based on the Department of Labor, and of course, they use the OES data that I previously mentioned. Okay, so at Depender, I intend to go ahead and file the 45J. Will not having filed it so far cause any issues? My lawyer at the time said you can wait for the RFE and don't need to file at that time. There was no J form. Um, I'd be curious what your immigration attorney now is telling you. Uh, I am of the opinion if there is an option for you to hedge your bet on the front end, then that I'm going to advise you, and I always have any of my former employees to let's file it. Now, your employer has to be willing to do so, right? Um, but when we talk about the I-485, those fees can be passed down to you, the beneficiary. So you can request to have that filed on your behalf as long as you're willing to pay for the fees associated with the filing. When attorneys say, let's wait for the RFE, that scares me because that creates more time for you. And so typically when an RFE is submitted, you have somewhere between 60 to 90 days to respond. And then, you're talking about these I-485s aren't filed in premium, right? So, there's an adjudication period as well. Um, I would ask your immigration attorney if you want to DM me after you talk to them, and let me know what they said. Um, I'd be curious to hear what they said. Okay, so Tessa is out. My wife is a union worker, so the prevailing wage is based on the collective bargaining agreement rather than the DOL prevailing wage. Okay. Um, yeah, that's kind of a one-off here in my experience. I'm sorry, unfortunately, I haven't worked with that. But the way I would interpret it based on the information that you've given me is that if she's being paid at or above the collective bargaining agreement, and that is listed on her LCA, uh, that would be um, the the numbers that I would work off of. Does that make sense? Um, so yeah, you said I was surprised when I saw it too. Apparently, if there's a CBA, DOL automatically recognizes that as the prevailing wage. That's interesting, and I can understand why. Right? You're talking about unionized representatives where there's uniform across the board as it relates to members of the union. Um, so very interesting. I've learned something new today, Tess. Thanks for taking the time to pose this question and join the stream here today. What I'd be curious to know, I'm assuming your wife being on an H1B, um, since there is disclosure across the board, how do her wages compare to her peers, meaning folks that are making at or above? Um, you know, similar rates to her. But very interesting. That's good to know. I mean, I think what it is it creates uniformity, right? It eliminates questions when you start to look at a CBA versus the Department of Labor. Now, I have in the past um, been part of some instances where we actually pushed back on a prevailing wage determination, used some outside sources that also run wage and labor statistics and provided those as examples. I've seen that done before. But again, Tess, thanks for taking the time to join this stream here today. Really appreciate your question and helping me learn something new. Okay, so at Synapse 660 says, I don't think the DAF for EB3 India will move since the final action date for EB3 India moved like a couple of weeks. So considering there's still a difference of about 4.5 years between dates of filing and final action, it seems like it would depend on if they reach the 7% country cap before that, although I do hope I'm wrong. Yeah, so we've been talking about that a good bit, right? Which is what is the total allotment that's available based on the surplus? I don't think anyone really knows. I've tried to calculate what those numbers would look like and how that would relate. And basically, you're talking about 16,000 roughly that may be issued, which is very interesting. Um, because if you look at what the allotment is, and if we start to look at all the folks whose dates become current based on those I-140 filing numbers that I went over a few weeks ago, um, you're in the 60 plus thousand range, right? So I wouldn't be surprised. I think we may see filing dates move a little bit. Or excuse me, I think we may see final action dates continue to move over December and even into January. I think you'll see, based on what we know now, I think you may see some of the very same inchings forward, which if we go back to it and look at it, you're talking about 6 weeks, 3 weeks, 3 weeks, 6 weeks, right? So you're not really talking about a lot. I mean, China, the EB3 China was the one final action date that jumped 3 months. Everything else was 6 weeks and 3 weeks. So very interesting. Good point. I agree. I think you're going to see some holding on the filing date. I think you will. But yeah, if I go back to your original question, which was, will that be through October of 2021? I don't think it will be that long, but I could be wrong. I mean, who, as of a month ago today, would have said the October Visa Bulletin is going to show a filing date of January 1st, 2015? So yeah, thanks, Snops. Really appreciate you joining the stream. Okay, so Chandra asks, my perm and I-140 was filed by my previous company. My current company is successor of interest, and EB2 I-140 has been approved a successor interest. Will there be any issues on EB3 downgrade? No, I mean, I think you have one of these cases, Chandra, that we talked about a good bit. If you're still watching the stream, can you let me know what is your priority date? I'm just curious because we've talked about folks that have this EB2 date that's now current based on the filing date of EB3. A lot of folks that I talked about back in early October that were kind of figuring out, hey, what do I do? I'm in this 2011-12 time frame. Do I sit and wait or do I downgrade? I'm still of the opinion to sit tight, although your situation sounds pretty straightforward. And I've advised folks that were with the same employer that were in EB2 that wanted to downgrade to EB3 and their employer supported them, that I thought their risk was minimal. I could see your situation applying similarly here. Um, Okay, so May 2014. Okay. Yeah, I mean, you're right under that number, right? And I'm sure you've been sitting there for the last month wondering what should I do and really giving this some serious thought and then hoping that we'd see some rapid forward movement here in November and your date all of a sudden would be even closer. Um, but I'll just ask you this question and you can answer it for yourself or you can post a comment if you want. And that's to say, you've waited this long. You work to earn EB2 designation, which is certified with much higher scrutiny. Do you want to jeopardize the possibility of we seeing some forward movement in EB2 versus going ahead and getting in line now that you're a month behind 60,000 others? Um, But again, I'm just going to go back. If you're with the same employer, it sounds like you have the successor of interest. Sounds like your risk is minimal here. Um, there has been some discussion around downgrading and upgrading. I'm going to be honest with you. The clearer your case is at the adjustment of status, the easier it is for the processing officer to make their determination. When you've got a downgrade, an upgrade, a downgrade, an upgrade, you start to wonder if I'm processing that case, are these requirements genuine? And as we are well aware of, they are looking for the smallest of reasons to deny cases right now. And so if your adjustment of status is denied, what does that mean for you? What's next? And so I don't say that to scare you. I just say it as we kind of think about what going forward is going to look like based on a lot of the changes that we've seen over the last several months. I think it's definitely proof that it's going to be much harder to live and work as an H-1B on a third-party client site here in the U.S. If you're a perm employee with an employer that's willing to go to whatever extent it is to get your adjustment of status filed, then, I would go with it. So, uh, Chandra, thank you for your comment. I really appreciate it. If you have any other comments questions or comments you'd like me to get to here today on the chat, really appreciate it. I had a few other things come in from Twitter that I wanted to cover. Give me just a second. I will post this here. Sorry, here we go. Okay. So at SBN 269071113 asks, can you please throw some light or give your opinion about how many FBGCs can be rolled over to EB for the fiscal year if the visa bans are still in place in February of 2020? Yeah, so I talked about that. a few weeks ago where I tried to do some basic math, and I came down to basically 16,000 was my like fuzzy math number. I know there's a lot of data guys out there that probably have a spreadsheet and can show me those numbers, and if they do, I'd love to go over that data. But yeah, I think you're looking at and your question, Krishna, is or Scott, excuse me, your question at SBN is around the family based, right? And so, uh, funny thing is, it's Krishna posts this: will family based leftover visas get added to employment based in fiscal year 2020 and 21? How many visas are available for EB2, EB3 in India category? So my calculation around that was it was around a little over 7,500. I think, and I'm sorry I don't have those numbers in front of me. Um, but if we're talking about how many are going to be rolled over and available, um, it isn't a lot because you still got that 7% cap, right? So even if you double that number, you're talking about 14%. It's not a big number. It again, it's only about 16,000 for India, and I think that's what we're talking about, right? I mean, we're talking about the country who's most impacted by the 7% country cap, which if you followed this channel for any amount of time, you know that I think is wrong. I think that having a 7% cap based on employment-based preferences for your country of origin is dumb, stupid. It's not right. So I don't know if I answered that question, but I sure hope that it makes sense in terms of when you look at the percentage allotment that's left over and how that would apply to employment based preferences for Indian nationals. Again, I think if we're looking at just going to talk about fiscal year 2021, because that's the year that we're in right now, you're only looking at around 16,000 that would be issued, right? And that's double what is annually issued. So, Krishna and at SBN, thank you for your questions. At SBN, that came in from Twitter. Had one more that came in from Twitter, and it's just from EV Guy, and he just said that doing away with the lottery is the best thing that happened to H1B. With that said, would Ayla gonna oppose it one way or another? As I talked about earlier, right? If the true intention is to eliminate the excess HCAP filings, then you're talking about thousands of dollars in lawyer fees to prepare those cases that are going to be gone. So yeah, I mean, as we've talked about a good bit, and it goes back to one of the most popular videos I've done, and what's the nexus between Senator Durbin and Ayla? Money. It's all about the money, right? So, Addy guy, thank you for that one. I really appreciate it. If you have any other questions for me on YouTube, go ahead and post those now. If you are still watching and like what I do here, please like this video. But I wanted to wrap up today by just saying thank you. Thank you to everyone who takes the time to watch my content. Thank you to all the messages, to all the emails, to all the support that I receive. Today is my 75th video here on YouTube, and I just can't believe how quickly it's gone by. I have done now, this is my 12th live stream that I've done. I've posted 63 raw, long form essay format videos on this channel. So this is a huge milestone for me here today. I am inching ever so closer to almost 2,000 hours watched here on YouTube. I looked earlier and I think I have 354 subscribers. definitely in a bit of a lull here on my subscribers. So I'm going to ask you, if you're watching this stream and you haven't, please subscribe to the H1B Guy channel here on YouTube. I just want to keep going. I want to keep producing content like this for you guys and girls. I want to keep talking about our broken immigration system and what we can do to reform it, what we can do to make it better so that it can be mutually beneficial for everybody. I want the legacy that I leave here to be just one that bridges the gap. And I think a lot of you that have followed this channel for any amount of time know that I have some conservative side and I have some liberal side, right? I am your definition of a moderate American is who I am politically and personally. It just is, it defines who I am. And I love talking about immigration. I love talking about the H-1B. I love talking about employment-based preferences. But most of all, I love being a voice for those who don't have one. And so thank you guys for allowing me to put out content like this. The H1B Guy Live that I did last week has literally over 5,000 minutes watched for a nobody from Atlanta, Georgia, who kicked this off at the end of June to be where I am. I'm just so humbled and so appreciative. So how can you help me? And how can you help the H1B Guy platform? That's to share my content, to tell your friends, to like my videos, subscribe to this channel, check out my website, read the blog, message me. If you're having interest in coming on the channel, I love to do Stamp It Out video or interviews where we do one-on-one, Stamp It Out live. I'm really excited to announce here on this live stream that on Wednesday, November the 11th, you need to go ahead and put it on your calendar. I have a very special guest who's going to be joining me for another round of the H1B Guy Live Stamp It Out Q&A 4. And so I will announce that very special guest next week. But I just wanted to go ahead and mention it to you guys that are still watching this video. Just really appreciate it. But if you'll check out the H1BGuy.com for more employment-based immigration benefits news, advice, opinions, if I can help you, if you're trying to understand what's best for you and your family as you're navigating the current immigration system here in the U.S., please message me. I'd love to set up a time for us to do a consult and see how I can help you. But I'm just so humbled to make it to 75 posts here on YouTube. Siva Raja, thank you very much for taking the time to drop this comment, for following here on the live stream. I really appreciate it. Chandra, I appreciate it. I can't do it without you. Krishna, I can't do it without you. Krishna, you have been one of the huge supporters of this channel with a lot of your comments, taking the time to watch a lot of my content and provide feedback and give me advice. Krishna, thank you. I really appreciate all your support. I had a few more come in on Twitter. I just wanted to grab really quickly before we wrapped it up. Poe is asking, since I mentioned February 21, you're assuming regime change, and in that case, it's very well possible the Dems will stop any spillover from family-based to employment-based. It is there in the current COVID relief bill, so we are in a very tricky situation. 226 divided by 12 is approximately 18.33K in the monthly visa adjusted. So far, October 20, approximately mid-March through September end, 120K spillover. So from October 20 to February 2021, you're looking at approximately 100K more in spillover will be available in October 21, if not before that. Really appreciate that data, Poe. Thank you. And that's really interesting if you look at it, because when we talk about spillover, right, you still are subject to the 7% cap. even if they were to double it. And it's interesting, and I've talked about the House Bill 6800, which I would plan to do a video on here in this channel, and I didn't, because it looked like it was the stimulus bill died. Of course, the Supreme Court Justice nomination and confirmation took precedent. But, very interesting. These numbers, of course, and we saw in House Bill 6800, they were going to restrict the family-based spillover, and they just snuck that right in. It's just amazing how politics works in this country. But I will say, and this is kind of my last little, I was asked last week who I thought would win the election, and last week, I felt like President Trump was going to be reelected. But if I'm being honest, I will tell you, if it goes back to the first debate, he has not done anything, in my opinion, that has won himself the election. And when you look at the Dow just dropping, I've looked at my retirement account over the last couple of weeks, and it's just gone down, 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 down. And you look at the spike in COVID numbers and the COVID exhaustion that we're going through here in the U.S., and, a lot of the polls are showing very large lead for former Vice President Biden. I'm still going to stick with my prediction. We'll continue to cover it here. This is not a political channel. We talk about immigration benefits, but I did want to do a follow-up. So, Abhijit, thank you. Again, you don't miss any of these streams. I just really appreciate it. I do call a lot of you friend, and that's the one thing about this channel that I'm just so appreciative of, is that I've had the opportunity to speak with folks in India, New Zealand, Mexico, the United Kingdom, Canada, Australia, and all over the United States. And every day that I get to do this, I just feel more and more fulfilled professionally, that I'm on the right path. So I need your guys' help to help me to continue to promote this channel. If you'd like to produce one of the H1B Guy videos and content that I put out on YouTube, please check the description. There's ways for you to support the H1B Guy platform. So Abhijit, just really appreciate you taking the time to join this stream here today. So with that being said, I do want to wrap it up. We're coming up here on an hour. Just wanted to ask you all again, if you like this video, really appreciate it. Please subscribe to the H1B Guy channel here on YouTube and click the bell for notifications. Tomorrow will be another episode of the H1B Guy News for October 30th of 2020. So check back tomorrow afternoon for that post. If you've made it this far, I just want to say thank you. Thank you from the bottom of my heart. Thank you for allowing me to get to my 75th video posted here on YouTube. Thank you for your support, for those who've taken time to help contribute to the H1B Guy platform and produce some of the shows and content that I've put out. I just really appreciate it. As I mentioned, we've got a lot of things planned over the next couple of weeks, so really excited about what's in store for you guys here on this channel. If you've made it this far, I just want to say thank you one last time. I really appreciate your support. The H1B Guy, your global source for all things H1B.